All right, this is my video about dealing with attorneys. Dealing with attorneys is never easy. They have all different kinds of personalities. Sometimes they're in a rush. Sometimes they're angry. Sometimes they're tired. They're just like everybody else. So, not easy. One thing you have to remember in most areas of law is that attorneys are business people. They do their job to make money. Attorneys aren't out there to give away their services for free. Sometimes they do for pro bono. Most of the time they don't. Pro bono cases are for um, indigent people that are needing something to be done, not people who are out to get money. If you're out to get money, you're not going to get a pro bono lawyer. You might get a contingency lawyer that's going to take, a percentage, 40, 50% of whatever he recovers for you if he's not charging you by the hour. That's what a contingency lawyer is for, but lawyers are business people. And so they take cases in order to make money. If they don't think they can make money off of your case, then they're not going to take your case. Attorneys range from 300 up to thousands of dollars per hour. I don't know many attorneys that take less than $300 an hour. But if you have a case and you want to sue someone for $1,000, that's what small claims court is for. Small claims court is for stuff that goes up to $8,000. So if your case isn't worth that much, probably an attorney is going to tell you you're going to go to a small claims court and do it on your own because they're going to charge you. So next, if you have a bad case or a low value case, the attorney's not going to take it on a contingency basis. If they think you have a chance of winning, but they think the chance is very low, you have the right to go to court, but the attorney is going to say you have to pay me by the hour for it, and you have to pay for all of the costs associated with that. And then if you win after trial, you can get your money back. But attorney's not going to sit there and spend hundreds of hours on your case and give up hundreds and thousands of his own dollars to prosecute your case so that later you can walk away, not show up for trial, give up, or uh, try to settle for next to nothing, and then your attorney gets nothing. It has to be a smart decision for the attorney if they're going to take a case on contingency. Um, Attorneys know that cases cost a lot of money. It costs $500 to file the case. It costs money to have the defendant served. It costs money $1,000 to $2,000 for every deposition. It costs $1,000 to $2,000 for mediation. Sometimes a lot more than that. And attorneys are not willing to lay out that money unless the case is a good case. That being said, sometimes attorneys will say, listen, I'll do a contingency agreement with you for my time. In other words, if I win you money at the end, that's when I get paid a percentage of what I get you. But you have to pay for all the costs. You have to pay for the filing fees. You have to pay for service of process. You have to pay for depositions. You have to pay for mediation. If you don't comply with discovery, or if you break the rules, or if you're difficult, and the judge says you have to pay attorney's fees for the other side for motion practice, that's all on you. That's not on the attorney. The attorney is not going to pay any of those things. So when you're talking to attorneys, attorneys ask questions because they want to determine if your case meets the elements required in order to go to court. Everybody thinks my right was violated, I can go to court and sue them. But attorneys know that there's a dozen or 2 dozen different things that the attorney has to prove in order to win the case at court. And so the attorney will go through from beginning to end of what those things are and ask you questions to see if those elements are met. And they want you to give them short, specific answers about the question they asked. One of the biggest red flags that attorneys get from clients is that when the attorney asks a question, the client doesn't answer the question, but talks about whatever the client thinks is important, or the potential client. When you do that, the attorney doesn't want to be your attorney anymore, because the attorney realizes if you're asked a question at a deposition, you're not going to answer the question. You're just going to talk about whatever you want to talk about. If you're asked a question at trial, you're not going to answer the question. You're going to talk about whatever you want to talk about. And if you're not going to answer your attorney's question and you're going to talk about whatever you want to talk about, of course, you're going to have less respect for anyone else that asks you that question. And that's what loses good cases. That's what makes an attorney from the other side look at your case and say, this guy can't even answer a question. I'm not going to offer them any money to sell. I'll offer them $500 because I know they're going to lose. And you know what? I'm going to take that deposition, that horrible deposition, and I'm going to send it to the judge. I'm going to ask the judge to dismiss the case because there's no case. And at deposition, they couldn't even answer a question to prove whether they had a case or not. Attorneys start with that analysis and that judgment of their own clients from day one, from the first conversation. If you fill out an intake form online, that information you put on there, the attorney looks at it and says, all right, is this going to be a good client or a bad client? Is this going to be someone who doesn't give me information or who has information? You want to go to court, you're going to get to trial, maybe in 3 years, maybe in 2 years. It takes a very long time. Sometimes there's administrative requirements you have to go through before you can even go to court. One of the worst things you can say to an attorney is, I don't remember, it was so long ago. Well, if you don't remember, that means you're not going to be able to prove your case. If you don't remember specifics, you're not going to be able to prove your case. I tell all of my clients, write down a diary for your attorney. Dates, names, specific, what, when, where, why, who, how. Those things you learned in the 8th grade in your civics class or your creative writing class, those questions, answer them all with details. We want first names and last names. We want witnesses that saw what happened that will back you up. You know, when you go to court, if it's just your word against their word, that's a bad case. That's flipping a coin. Attorneys don't take cases to flip a coin. If they want to do that, they go play blackjack at the casino. They're not going to take a case that's a 50-50 shot. But if you've got evidence to back it up, that's good. But here's what you can't do, okay? You you can't tell your client you must have been treated differently or treated illegally or your rights were violated because they didn't do something they should have done or because of a negative. It has to be something you can prove that when you go to a jury, when you go to a judge, they're gonna be like, oh yes, they did this. Or the law said they were supposed to do this and they didn't do it when they were asked to. But coming to an attorney and saying, well, I was fired, but they didn't give me a reason. And I do a lot of employment law cases. That's why I use it as an example. I was fired, but I wasn't given a reason. I want to sue them. That's not okay. You don't have to be given a reason to be fired, especially in Florida. Um, and so you can't assume that the law was violated and not know. You also never want to call an attorney and just want to tell them a really long story and say, so do I got a case? Was the law broken? That's wasting the attorney's time. Attorneys don't like that. And that's another red flag, a sign of someone who, even if they did have a case, they're not going to be a good client and they're not going to be able to present themselves well enough for deposition or trial. Um, you don't want to file a lawsuit against someone just because you're mad that they did something you don't like. They have to have actually broken a law. And I put a lot of videos out there on the different laws that I deal with and what it means to break the law and what you need to be able to show when you talk to an attorney. So watch the videos and see if there's one about you, your specific situation. All right, what else? Uh, Lawsuits are long and arduous processes. You have to keep in contact with your attorney. If you change your phone number, if you change your email address, if you move, you got to tell your attorney. If we file a lawsuit and then we can't get a hold of you, we have to tell the judge, hey, we lost our client. We can't get a hold of him. Case dismissed. You lose. Bad things, right? What else happens? The defendant says, well, I want that person to pay all of my fees and costs, and I'm going to go sue them later. I'm going to get a judgment against them because they disappeared. And also you have to remember, in a lot of different situations, when you go sue someone in court, if you're wrong, that's not good. You're going to have to pay the other side's fees, costs, expenses. If you're right, you win and you get money, right? But you don't get to go start suing people and lying to attorneys and making things up and then lose. Because then you've used court resources, attorney resources. The person you're suing has spent time and money and effort. And courts don't like to let people get away with those kinds of things without having to pay. So these are things you should always consider before calling an attorney and things you should always understand. Does this apply to every situation? No. Everybody's individual situation is different, but you have to understand how to deal with attorneys because most people don't and most people don't understand. And so that's why I'm putting this video out there because I'm an attorney and these things happen to me. And I want every attorney to have a client that's watched my video that deals with them in the right manner. So don't call your attorney when you're driving in a car. Don't call your attorney when you're busy. Don't call your attorney when there's kids screaming in the background. Don't call your attorney when you're cooking. That just tells the attorney that the lawsuit and your issue is not that important to you. Don't think you're just going to hire an attorney and sit back and wait for the money to come in. That never happens. You have to be an active participant in your case. When discovery happens, you have to comply and answer every question, whether you want to or you don't want to. You have to provide documents, whether you like it or not, whether you think they're relevant to the case or not. You have to do what your attorney says. If the attorney says, get the document, and you say, but I have to go 50 miles and pick it up from my old doctor, then you're going to do it. Because if you don't do it, your attorney says, then I don't want you as a client anymore. Because if you're not going to help me prove your case, I don't want to help you prove your case. Goodbye. Go find another attorney. And once you have one attorney and that attorney leaves you, it's very hard to find another attorney because attorneys know that if your first attorney fired you, or you fire your first attorney for reasons like they weren't moving fast enough when these cases take years and attorneys have tons of cases, or you didn't like their decisions, the next attorney just thinks, well, you're going to do the same thing to me. So let me stick with a different client that's going to have a different perspective when it comes to litigating cases. And we know, all attorneys know, 99% of the cases settle, 1% of the cases go to trial. But what an attorney should do, which is what I do, is I look at every case as if it's going to trial. Because if I look at every case as if it's going to settle, I'm not going to do as good of a job as I would if I was going to go to trial. And then what happens? What happens is the one that doesn't settle, I haven't prepared properly. And so then what happens after that? I walk away from the case before it goes to trial because I don't think I can win. And then the client is left holding the bag. Read those contracts. We walk away from cases for many reasons. If we make a recommendation on a settlement and you don't agree with us, that's fine. That's your right. But remember, if we say you should settle the case for this money, it's a good offer, and you say no, we can leave you. It says it in our contract. If the defendant has facts and files for sanctions saying this is a frivolous lawsuit, and we get those facts that you never provided us in the beginning, and it looks like, yep, you lied to us, you didn't tell us the whole truth, you didn't tell us the important facts that we needed to know, and it does look like you're just being vindictive and suing someone, we'll drop your case and we'll walk away. And so you have to take those things into consideration when you're talking to an attorney, when you want to retain an attorney. Um, Playing games with attorneys doesn't go over very well because once we start investing time and money in your case based on your representations to us, and we learned that some of them might have been misrepresentations, exaggerations, like you were really fired for something severe, but you forgot to mention that to us, and you said you were fired because, you know, your English wasn't good and it looks like a race or national origin based case. Um, but you were doing drugs on the job, and you forgot to tell us that. These things don't go over well with the attorneys and they don't go over well with the judges either. And remember, the contingency is always just the attorney's fees. If I spend $3,000 on your case and you lose, you have to pay that money back, the costs back, not my attorney's fees, not my hourly rate, of course, because it's contingency. So you lose, you don't pay. But the filing fees, the deposition fees, the mediation fees, those are always your responsibility. If I don't make you pay it in the beginning and you lose or you decide to walk away, it's not, I'm going to let the attorney foot the bill and lose money on it. It's that you owe that attorney money and you have to pay them back. So you always have to take that into consideration that this isn't a no loss scenario for clients. If you want to sue someone, you have to be ready to invest your time, your money, and your efforts into it. Now, that being said, there's a lot more behind dealing with attorneys, and I may do some more videos in the near future. If you have questions about certain areas of law, very soon I will have longer paid online videos so that those questions can be answered. Thank you.